My name is Michele Dubbini and I'm a lawyer, and I'm part of the training team of the European IPR Helpdesk. Perhaps somebody of you knows us already. For those who don't, I brought a couple of slides. Just let me introduce that a couple of minutes before we start. Those are all the services that we offer as free of charge, of course, because we are already paid by public money and we shouldn't apply fees on our services. What we do is basically try to make life easier, as I said before, by having publication explaining what intellectual property rights are and perhaps how to use them inside the Horizon 2020 contest, or also for exploitation activities. So let's say license templates or non-disclosure agreements templates that sometimes can be very useful, crucial, I would say, especially in the early stages of the project or during the exploitation activities. Then we've got trainings like today on site, but also online. And I would suggest you perhaps to visit our website and see where the next webinars are, because we tackle thematics like consortium agreements or exploitation and innovation, the thematic of innovation in Horizon 2020, trying to explain what it actually means and how to address it inside a proposal. And there's also a couple of regular communication that should come to you while once you have registered into our website. So we have newsletters and bulletins, respectively, that comes once every 2 weeks and that comes once every 2 months. Those are the webinars, activities that we offer. The next is actually IP management in Horizon 2020 with a special focus on Marie Skłodowska co-reaction. We have been speaking about that a couple of times today, I heard. So perhaps it could be useful to follow that one as well. What kind of thematics are there to be acknowledged while writing a proposal in MSCA, especially with regard to intellectual property rights? It just costs 1 hour. As I said, it's for free, and they are available on our help website for registration. I went through this one as well already, but on our library, you can see a couple of guidelines that perhaps I will send afterwards to Liane so that you can have access to them regarding general topic in Horizon 2020, but also specific templates for licensing agreement, for consortium agreement, or non-disclosure agreement that can be very useful, especially if a SME or a researcher does not have any idea from where to start by writing a NDA, for example. And those are the guides that we offer. So Guide to Intellectual Property in Horizon 2020 that explains the most important rules that I'm going to introduce afterward in this presentation are much better explained here, I would say. And then the rules for commercialization of results produced. And here, another guide regarding the registration, so how to protect intellectual property through intellectual property rights in Europe. And here, we have one last guide, probably the most interesting, that explains the concept of exploitation, of communication, and of dissemination, which they are usually confused by as our user, the user of our services. Last but not least, we have a helpline that answers to direct questions of users within 3 working days using the most understandable language that can be used, at least from our patent attorneys. And in the presentation that I'm going to start afterwards, I put a couple of dubs of questions that statistically are emerging from those users that are coming out in our day-to-day answering activities through this helpline. And perhaps we can discuss about it and we can see how, or if you had the very same problem in the past, and hopefully will not have it in the future. Those are our colleagues, I would say. So that's probably very important today because we are responsible for what's happening pretty much in Europe. And we try to answer around for questions that are coming from Europe and are in scope of intellectual property right in Europe. However, there are also other institutions or consortium that are there to answer questions regarding intellectual property, specifically from China, from Southeast Asia, and from South America. So that could be very useful because we cannot know what's happening all around the world regarding intellectual property and intellectual property right, or what kind of rules are there in order to file a patent in Brazil or in Argentina, but they do. So that's a very interesting thing to check also regarding potential exploitation activities there with those entities as well. And then, excuse me for my institutional presentation, but I thought it was useful to know each other and see what our project is pretty much doing. That is the content instead of the presentation that I'm going to give afterwards. Honestly, this presentation, we usually do that for coordinator or for beneficiaries that are going to be part or that are writing a proposal for Horizon 2020. However, the rules that I'm going to introduce are as important for them and probably twice as important for partners that are outside the European Union, that do not really know or not have the chance to know those rules. And I think it is a responsibility for a coordinator or for a partner of the consortium to make those people aware of those rules and how pretty much it works regarding intellectual property and intellectual property rights. I will start by the basic terminology and agreements, so consortium agreements and grant agreement, because there's a couple of points there that are interesting also for me in order to ask to you. And then I will introduce the grant agreement rules and the place for flexibility that we have there. So, for example, the obligation to protect, the obligation to exploit, the obligation to disseminate, and I will also add what kind of consequences they might have on third parties that are taking part to projects from outside Europe. And the services I've already told to you. And finally, here and there within the presentation, I put some problems and questions that small and medium enterprise asked to us. And perhaps I also ask you a couple of questions because I'm also here to learn, since we do not have a huge amount of requests or cases from outside Europe. So let's see if everything goes well. I'm going to learn something as well today. So this is the general statements because it is important to consider intellectual property in Horizon 2020. The rules for participants establish the best set forth commitment to exploit their own results, but how they exploit is a very, very important thematic. And we will see later on that statistically the most viable exploitation way are licensing or assignment of intellectual property and intellectual property rights. But there are limits to that, especially for partners outside the European Union, the European community. And those limits, for example, are the Article 30.2 and 0.3 of the grant agreement that are saying that each beneficiary that would like to grant exclusive licensing or assign intellectual property outside Europe has to communicate that to the European Commission that can oppose to this transfer or license. And that is very important because the Commission could also decide to draw back, to take back the amount of funding that had been destinated to the project, to the partners, European or outside Europe. So we need to pay attention to that, and that is probably the most important issue that I'm going to talk about today. The other points here are actually for coordinators and other beneficiaries, because the outline of the intellectual property management, protection, exploitation is a crucial part of the impact phase of the proposal, and there is where the most of the points are actually getting lost because those items, those issues are not addressed correctly or as deep as that could be. But we're going to see that later on. Of course, it very much depends on the kind of project that we have under our hands, because here, up until here, we will not have such large examples of intellectual property rights coming down from intellectual property. We're not going to have patents in this white here of technology readiness level. Here, our exploitation way could be further research, could be other kind of exploitation that is not really inside the market as we can have here. So the technology readiness level of the beginning and the end of the project is the first factor that can let us think that perhaps there might be problem, especially from an outside Europe point of view, of the intellectual property that is going to be produced and that perhaps is going to be licensed or assigned. So this is a very good indicator and hint giver of potential problems that could arise from the intellectual property produced inside the project. As long as we are here, I would say, we just need to pay very much attention to the dissemination activities, to the fact that the dissemination activities are planned, that there is not going to be no kind of early dissemination, and then we are pretty much fine. When we come instead in this zone here, where the market is much more nearer and where there are larger risks to either get inside or a larger opportunity to get inside the market, then there is where we need to pay the most attention, at least under an intellectual property point of view, given the rules that we have from the grant agreement. But let's start from the very basic. This slide, you know much more about me, but the intellectual property rules are available, and they can be found in the rules for participation, either also inside the grant agreement and the applicable work program, of course. But a lot of information that I'm going to give about Article 30.2 and 30.3 are actually taken from the annotated model grant agreement. So they are available there for you as well. And it's much more better explained than what I can do in 30, 45 minutes with examples as well. This is the key terminology for a H2020 project, which is background, of course, results, exploitation, dissemination, and access rights. You certainly came across, those terminology, but it is important to define and also explain to the third parties what this word means and what kind of consequences it has. For example, regarding background, we know that inside the Horizon 2020 scheme, background is tangible or intangible input, which is held by the project partners prior to their accession to the agreement. However, perhaps not everybody knows that the background has to be identified in writing, and that is where we're going to do that in the attachment 1 of the consortium agreement inside the project. And also for European partners that are not very experienced, that is a crucial nevralgic area that they do not know very well, and therefore may commit some mistakes in filling this attachment 1. What is the role of the attachment 1? Is actually providing to all the partners with the necessary technology or information that they're going to need throughout the project. That means that if we are the coordinator, for example, with third parties inside the project from outside Europe, and we leave behind some part of that, it could be harder to get those information when they're going to be needed. That means that some time might be spent in order just to retrieve that information. That means that sometimes it's going to be lost within the project framework, and that is something nobody would like, or at least in our coordinator experience, what they do not have is actually time at the end of the day. So check out this one, this attachment 1, twice at the beginning of the negotiation when the consortium agreement is going to be signed, but I will come to that in a couple of slides. And the second terminology is results or foreground, as we knew it from FP7, which could be, of course, results, you should perhaps remember that results is a synonym to intellectual property. That is an interesting point in the sense that results are, intellectual property is the product of the mind that is produced by the human brain. And that is exactly what here results are. And just to make you a difference between intellectual property and intellectual property rights, the one is the results, the product of the mind. Rights instead are the human construction, juridical construction that are used in order to give a form, physical form, to those results and to protect them. Just a juridic bracket, because we see in our questions that coordinators tend to make a huge confusion between intellectual property and intellectual property rights, ways of protect, and ways to generate their results. So remember the difference between IP and IPR. And that would be already an achievement for me today in the presentation. And then, of course, access rights. Third parties in the proposal or also in the project will have access rights to the results. Is that fine for all the European partners? How is that going to be regulated? What kind of limit to access are they going to have? Those are interesting questions that can be regulated within the Consortium Agreement. And we have limits given by the European Commission, given by the grant agreement. Again, Article 30.2 and 30.3. License may be there and must be there as long as they are not exclusive. If they are exclusive or there are assignment to the results, then we have another set of rules coming in from the European Commission. Then exploitation. What does exploitation mean? Which is the utilization of the results in research activities or within the economical area or monetization. It is important to remember exploitation does not mean to monetize. Exploitation actually means to make use of the results. So further research is perfectly acceptable. For example, for those results that I was showing with lower TRL at the beginning of the presentation. And then finally, the last terminology, for which I think I have a slide also later on, is dissemination. Dissemination is a way to present the results to the public, but dissemination always goes together with the word results. We may not have any dissemination activities as long as we do not have results available throughout the project. And that is the great difference between communication. And that is the mistake that all coordinators or all participants actually do. They confuse this word communication and dissemination. And at the end of the day, those are perhaps the points that are going to get lost and then make the difference between a finance proposal and a proposal that is actually not finance. So remember, dissemination of results, communication of activities. But probably you know that better, better than me. And I have it here just to give a small example. The communication of the activities may start, let's say that here is January 2019. The communication of the activities has started already at the beginning of January, because when we show who our main principal investigators are or which institution are there, then we are actually doing communication activities. Also, the creation of the website is a communication activities. However, we start with the exploitation and the dissemination of results, possibly together, let's say, in May 2019, because that is the first month where we're going to have results available, and the first month where we can concentrate ourselves on the results and disseminate them. But there might be no dissemination activities here because we still do not have results generated. So pay attention to that. And I just say that in order to make sure that everybody in the consortium knows that. And those information come also across the geographical barrier of the European Union, and also partners from outside the Union have this information as well. Then also to go on with the basics, the grant agreement. I'm not going to tell you what the grant agreement is, but it is important, at least in my opinion, to always remember that the grant agreement is our link to the European Commission, and that is pretty much the constitution of the of the project that we're going to carry out. That means that no other rules within internal agreement of the consortium may in no way contradict what is basically written in here. And that has a large importance when we're talking about ownership of results, so Section 8 of the Consortium Agreement, because we may not write anything in there that goes against Section 30 or Article 30 of the grant agreement. And it happens often, especially from overseas institutions from the US, that there is try to adapt the rules to what the rules actually are in the US, try to change the ownership provisions that are done inside the consortium agreement, and there is where we can find the largest number of conflicts arising within the consortium agreement negotiation. And a way to solve this is just to say that the provision that they've entered inside the consortium agreement section 8 are not actually compatible with what is written inside the grant agreement. That, being our constitution, may not be contradicted by other rules inside the consortium agreement. But I'm going to come back to that. This is the annotated model grant agreement, where pretty much all the information from this presentation come from, so you can just consult that, and I know you are doing that already. But then let's come instead to the consortium agreement, and I would have a question for Marie, who's not there anymore. She was there. Because we were talking about before the project with outside partners, so the Indian, and I was curious to know whether they could finally finalize the consortium agreement in time before the starting of the project itself, because that is an issue that we have found and that we have also, especially also with just European projects, that we come to the day of signing, so here the time to grant, so when the coordinator is going to sign the grant agreement without a consortium agreement. And then theoretically that is an issue, because the rules are telling us that the consortium agreement should be worked out during the time to grant at the latest. But statistically it is very hard to comply with that and to come with the consortium agreement ready at that moment. And I think, and we saw it actually in the requests that we have received, it is even harder when third parties are actually involved, especially third parties from the United States, for example, that have a completely, I would say, different mind regarding exploitation of university of results. So the fact, in my opinion at least, that the consortium agreement is a little bit late after the time to grant is not dramatic. It is true, the rules would say that it should be ready, but it is more important to have a strong, solid consortium agreement with all the rules actually written properly, with all the partners agreeing, instead of having a very clumsy one at the beginning of the time to grant. And I'm saying this because there are actually no, and maybe you can correct me if I'm wrong, there are no consequences for being a couple of months late for the date of signing. The point is, at least we suggest, to have the consortium agreement ready as soon as the results are going to be generated. Because in that time, there is when we're going to have the ownership, when it has to be regulated, the access right are going to be regulated, the request for the access right has to be regulated, the time for dissemination has to be regulated. So the very neuralgic time is not the time to grant in itself, at least for intellectual property purposes, but it is the creation of the result and when the results are going to be available. There are a couple of models that we offer as well offline, which are the DESCA model, the M card, and the UX card, and IMG4, that can help with the writing down of the consortium agreement. And I wanted to ask, perhaps, has somebody of you experience or have seen some consortium agreement with third parties outside Europe, how they behave, what kind of request perhaps they had, and what kind of reaction did the European parties have. I wanted to introduce the most important rules that may generate problems regarding, for example, the ownership of results. That is the first one, the obligation to disseminate, the obligation to protect, and the obligation to exploit. And perhaps a couple of hints on how they can work together with a consortium agreement and help. Or perhaps we can also say whether it can be useful or not. Because, so that is the first rule coming down from the grant agreement. So in Horizon 2020, generally the grant agreement establishes that the results of the project belong to the participants that are generating them. That is a very general rule that very often does not satisfy the participants, because it is very nice and clear, but is also very gray, in the sense that if we are 20 partners, 19 partners that have taken part to the generation of the project, then we're going to be all co-owners. But what is going to be the percentage of the ownership, for example, that we're going to have to that, and how are we going to deal with that within the project? And so the grant agreement is giving us the general rules, and then with the consortium agreement, we have the chance to go and a little bit in details and see how we can actually find a solution and see who is going to be owning what and to which extent, for example. Within the DESCA model, for example, we have the chance to see if we can have joint ownership agreements with the other partners. So here, the other point beside the ownership of results that we usually try to explain are access rights. Because it very often happens, for example, that university would really like to have ownership of the results that they generate because it's good for them in order to have them in the CV of their researchers in something. However, they're not really going to use the results afterwards. And that has a lot to do with the access rights to those results. Why? Because partners may have or will have access right to the results during the project or for the project implementation, royalty-free if it's going to be used for project activities, or if it's going to be used for exploitation activities that may be on royalty-free or on fair and reasonable conditions that normally are applied to that. But this means that also outside of the European partners of the consortium, the access is going to be given. And we're talking about the results that are generated, but also the background. What I told you before was going to be written inside the attachment 1 of the consortium agreement. That means that each and every partner signing the consortium agreement is actually leaving access to this background to the other partners from outside Europe and vice versa. So that is something that should be thought twice and see what kind of relationship, for example, third parties have around the world, if they are with competitors, and that is something that companies check, I would say, before signing the agreement, or anyway leaving access to their backgrounds to third parties. Another important thing, I think, in the slide before here, is that those results are, or background, are royalty-free for project implementation or use of results if they are needed. And what is needed is defined inside the consortium agreement. Again, it can be a pro forma actions to write what is written in there, to define what is needed, but it can be useful because that way a partner can say, yes, this is needed because we've had written expressly that within the definition of the consortium agreement, for example. And in this way, there's going to be a access to background or to results. That is an example that we've had where a partner really wanted to make sure that he would have access to certain results or background once the time would have come in order to utilize that. And therefore, he decided to write down what needed for certain result meant within the definition of the consortium agreement. That can be done, that cannot be done. It is a choice of the partners of the consortium. Now, we come then with the obligation to protect that the grant agreement is telling us. Each beneficiary has to protect the results each and every time that is they could be reasonably expected to commercially or industrially exploited, and very importantly, when the protection is possible, reasonable, and justified. So the protection is possible, I think we have it here, applying the subject matter of the intellectual property that we can see here to the human construction that are given there. So we may protect an invention through a patent, we may protect a software through copyright, and that is the requisite of the possibility. Meaning that we may never protect an invention through an industrial design. That is not possible. And it doesn't make sense also to write that within a proposal. And what the suggestion we try to give in this way is to try to preview what the results are going to be. And if you think that you're going to have the inventions, well, you're going to have an invention with intellectual property, then you're going to write up that you're going to have a patent instead of saying generically protect the intellectual property rights that we're going to have produced. That is important, I was saying, to think about that from the very beginning of the proposal stage, because the costs are eligible costs. So that is pretty important to remember. As long as you put them in the budget, they're going to be reimbursed. And I'm talking about costs all around the world, not just for European protection. So not just the European Patent Office, but also the US Patent and Trademark Office, China, and so on. And yeah, the second obligation, also going pretty quick, is the general obligation to disseminate. We know that the grant agreement is telling us that project partners are obliged to disseminate the results as swiftly as possible. But sometimes that so quickly as possible is slower than must be slower than the protection activities. Because otherwise we are going to be in breach of the rules of the grant agreement. What does that mean? That no dissemination of results may take place before the decision is taken regarding the possible protection. So there must be rules within the consortium that tells to the partners, wait before you publish, especially to the university, because if you publish too early, then we're not going to be in the position potentially of having protection on the results that we are going to generate. And that's why that is probably, and that goes together what Stefan was saying before, that the Consortium Agreement is a little ein vade mecum document that says how the consortium should behave, and that is the example, I would say the brightest example of that. Because in there, in section 10, we've got the chance of giving us some rules, so informing consortium partners 45 days before that a planned dissemination activity is going to happen, and give them a chance to make an objection. Because if we do not do this, then there is the chance to lose novelty, and therefore lose the chance of protecting intellectual property rights, and therefore losing exploitation activities that otherwise wouldn't be possible. And that is something that also third parties should be aware of, because not just because you are outside Europe, you are able to publish whenever you'd like. Because if a examiner at the European Patent Office or in every other office in the world is going to make a novelty check, is going to check also what has been published outside Europe, not just inside Europe, which means that the whole consortium is going to lose potential exploitation activities because there has been no protection. And the whole consortium is also in breach of the grant agreement because the protection was possible, was there, but hasn't been carried out. So, and also our general rules that we give is make sure that you comply with the obligation to protect, and afterwards you comply with the obligation to disseminate. This is their importance, and it has to be clear for the whole consortium. Publish, right, that's good and has to be done, but after a thorough reflection regarding protection has been carried out. Then finally, we have the general obligation to exploit, meaning that the use of the results, as I was saying before, for further research, developing or creating other, or monetizing. And I underlined here a couple of examples, like the licensing of IP rights or the selling of the IP rights. The license and assignment of intellectual property rights. First of all, because those are one of the most used exploitation ways that can be done. And secondly, excuse me, I need to look for this. Also, I have the wrong slides here. Excuse me. The first thing is because the selling and licensing IP rights are statistically the most widely used. And secondly, because we have a rule from the grant agreement, Article 30.2, that says that in those two cases, for selling of IP rights and for exclusive licensing outside the European Union, the beneficiaries must communicate to the European Commission, notify to the European Commission 60 days before the selling takes place, in order for the European Commission to validate this selling. And the partners must need to communicate and identify the results concerned, described in detail what kind of owner they are going to have for those results, and why this selling or assignment or license is going to take place. It is important because there were a couple of cases where the controls of the European Commission were done and actually no notification had taken place, and therefore the license were given without authorization, and the reaction of the European Commission is calling back the funding that has been given to the partners, either inside or when those fundings has been given to the outside beneficiaries to the consortium. This is the Article 30.2 and 30.3 of the grant agreement, 302, 303. And this is a general rules that is very small written, I would say, in the grant agreement, and that very often is forgotten. And it may have catastrophic consequences because forgetting to communicate to the European Commission that a license or an assignment has taken place could mean consequences for the consortium. And given that statistically those are the exploitation ways that are mostly used, it is always good and better to check one with the all partners of the consortium. The novelty here. So for us within the project, we should consider novelty as a cross point between the protection activities and the dissemination activities. Why? Because we've got two obligations here. We've got the obligation to protect. Meanwhile, we also need to disseminate. So what are the questions that we receive? The coordinator says, how can I on Earth disseminate and protect at the same time? Because if I disseminate, then there's no point in protecting anymore. And the answer here is there is a point in protecting if you do that before disseminating. Because the rules regarding novelty, they say that whatever is prior art here, so whatever is part of the state of the art, so everything that is made available to the public before the patent application, then will break our patent, will make that our patent is not granted anymore. So let's say that we have the results coming out on the 16th of April, and we want to publish them. What do? We communicate to the other partners that within 45 days we are going to disseminate those results. What would happen if those results are patentable? Another partner is going to tell us, I have an objection, I'm sorry, because I would like to patent those results as my exploitation activities are about the patent that I would get from that. I want to license that patent, and if you publish that before I can file this patent, then I'm not going to be able to license it anymore. And we all have a problem because the exploitation activities that I would have carried out or we would have carried out are not available anymore. And that would be the slide here if I would have time to, to explain that. That is the this monopoly given by the protection let us set up licensing or assignment that are about the intellectual property protected. Without this layer here, the pyramid actually cannot stand, because we cannot have a license about the intellectual property that does not exist or may not exist anymore, and therefore we cannot also reach other levels of exploitation activities here. So if in the proposal is written to license or assignment the results as an exploitation form, check twice, because then it could be really a problem to see to carry out those activities if protection activities have not been taken in the good step before. Sorry, I was a little bit late, but yeah, I will also send out my presentation corrected, because a slide was missing and it was very important.
So thank you, Michele.
Thanks to you. It's been hugely interesting for me. Thanks.